The Nkabinde Inquiry, Irony, Paradox, and Questions. In a quiet chamber where legal language replaced ordinary speech, the Nkabinde Inquiry unfolded like a drama no playwright would dare invent. It was meant to be a disciplinary proceeding, structured, focused, and purposeful. Instead, it began to resemble a theater of contradictions, where the script seemed to change mid-performance and the actors spoke lines that undermined their own roles. At its heart, the inquiry was supposed to examine whether Advocate Chok remained fit for office. That was the stated purpose, the official curtain raiser. Yet, as the proceedings progressed, a strange irony crept into the room. Irony in the House of Discipline. The disciplinary inquiry into Advocate Chok's fitness for office soon became an investigation into others, most notably Advocate Batohi and the Kato Manor Unit. It was as though the accused had become the narrator and the witnesses had become the subjects of judgment. The irony deepened when the terms of reference were read aloud. They referred to the Buizan and MDLUL, high matters, two high-profile legal storms that once shook the criminal justice system. These were meant to be the focal points. Yet, as the inquiry stretched on, much of the time was spent examining other cases, drifting further from the original mandate. It was like convening a trial for theft, only to spend most of the hearing discussing unpaid traffic fines. The official reason for the gathering remained on paper, but the conversation in the room wandered elsewhere. The paradox of independence. Then came the paradox, quiet at first, but impossible to ignore once spoken aloud. In his opening statement, Advocate Chok spoke passionately about the independence of prosecutors. He warned against second-guessing their decisions and stressed that prosecutorial discretion was a cornerstone of justice. No one, he argued, should undermine that independence. But as his evidence unfolded, his tone shifted. He began to complain about decisions taken by Advocate Batohi, criticizing her judgment and conduct in several matters. And so the question arose, hanging in the air like a legal riddle. Was independence a principle or a privilege? And if it was a principle, did it apply to all prosecutors or only to some? The inquiry, meant to clarify facts, instead produced philosophical puzzles. Questions around testimony. Advocate Nako's testimony added another layer of uncertainty. On the 9th of February 2021, the Minister of Justice informed her that President Cyril Ramaphosa had requested reasons why she should not be suspended. 5 days later, on the 14th of February 2021, she asked to resign. Yet in February 2026, she testified before the Nkabinde Inquiry that she had been pushed out of the NPA and forced to resign. This raised an obvious question. Why did she not use the opportunity at the time to defend herself with the same evidence she now presents? Why were these allegations not reported to IPID, the Zondo Commission, Parliament's ad hoc committee, the Madlanga Commission, or a court of law? She is, after all, a senior advocate with full knowledge of the available legal remedies. Advocate Salomema's position also invites scrutiny. According to public reports, he led prosecutions in 3 high-profile cases that weakened public confidence in the NPA. The racketeering charges against former KwaZulu-Natal Hawks head Johan Buizan, the fraud case against former IPID head Robert McBride, and the prosecution of former SARS officials in the so-called Rogue Unit matter. All these cases ultimately failed. Having since retired from the NPA, he now claims he was pushed out by Advocate Batohi. This raises a broader question. Are Advocates Nako and Mema using the Nkabinde Inquiry to settle scores with Advocate Batohi? Has the inquiry become a battlefield for rival factions within the NPA? The limits of administrative power, beyond the ironies and paradoxes, lie the hard edges of administrative law code, procedural and unyielding. The inquiry is a creation of the National Prosecuting Authority. It is not a police body and has no mandate to investigate the South African Police Service. Its reach is confined by the NPA Act and its own terms of reference. Yet much of the inquiry's attention drifted toward the conduct of the Cato Manor Unit of Police Formation. This alone raises questions about jurisdiction. Can an NPA inquiry probe the actions of the police, or is that territory reserved for bodies such as IPID? Then comes an even more practical complication. Advocate Batohi has already retired. If the inquiry were to make adverse findings against her, what then? It cannot recommend her removal from office. One cannot remove a person from a position they no longer hold. Such action would be moot, legally interesting perhaps, but practically meaningless. At most, the inquiry could recommend that the president refer matters to other bodies, to IPID for police investigations, or to the new NPA leadership for possible prosecution. But those bodies would run their own processes and make their own decisions. They could proceed or decline to proceed, especially given that the cases in question are old and, in some instances, ended in acquittals. In other words, the inquiry can point, suggest, and recommend. It cannot compel. A president's dilemma. Even the president, the highest executive authority, would find his hands tied. If the inquiry produced adverse findings, he could not remove Batohi, she has retired. He could not discipline the Cato Manor Unit SAPS, has its own internal processes. All he could do is refer the matter elsewhere. Those referrals would not be purely political acts. They would be administrative decisions, subject to judicial review under the Promotion of Administrative Justice Act, PAJA. If the president's decisions were not rational, lawful, and procedurally fair, they could be set aside by a court. Thus, regardless of the inquiry's conclusions, the president could not act freely. His decisions would be constrained by law, reviewable, and possibly reversible. The inquiry begins to resemble a long preface to actions that may never occur. Questions in the quiet, and so the chamber fills not just with evidence, but with questions. What is the purpose of an inquiry that cannot enforce its own conclusions? What is independence if it is invoked for oneself, but denied to others? What does accountability mean when the accused has already left office? And what is the value of recommendations when neither the recommender nor the recipient has jurisdiction to sanction the individuals concerned? The Nkabinde inquiry, intended as a legal process, becomes a study in irony and paradox, a proceeding about discipline that disciplines no one, an investigation into one person that focuses on others, and a search for consequences in a space where consequences are legally limited. In the end, the inquiry does not merely examine facts. It exposes the strange theater of law and administration, where mandates are narrow, powers are divided, and outcomes are often less dramatic than the proceedings that lead to them. And as the final arguments echo through the chamber, one lingering question remains. Was the inquiry ever about resolution, or was it always about the appearance of it?